Welcome to Leargas's training on GDPR and information security contract requirements for beneficiaries. The purpose of this course is to provide you with an overview of the information security and GDPR requirements of your beneficiary contract with the national authority, Leargas. At the end of this course, we will have explained the information security and GDPR clauses in your beneficiary contract, what you need to do or have in place to comply with those clauses, and we will also explain the compliance reporting under the contract, which you must complete as required by the European Commission. In the following slides, we will examine the actual wording in the contract agreements and explain how you can comply with these requirements. The first relevant section within the contractual agreements in relation to information security and GDPR is in Section 2. Section 2 of the agreements covers the rules for carrying out the action. Within Article 13 of this section, it specifically notes the rules in relation to confidentiality and security. Article 13 covers three specific topics, and these are sensitive information, classified information, and consequences of non-compliance. Now let us look at these specific requirements in a little more detail. We can relate these requirements back to the data retention slides that we covered in the GDPR training session. All data, be they in paper or electronic form, should be considered confidential, and as such, should be secured from unauthorized access. We must keep data only for the agreed period of time to complete the agreement, and this will be set out in the agreed data sheets, which will be provided to you by Leargas or the European Commission. If there is a requirement to keep any of this data for a longer period, you must formally request and be granted permission to do so by either Leargas or the European Commission. It is important that you understand that the data cannot be used for any other purpose except to implement the agreement. You may disclose sensitive information to your employees or a participating entity if and only if there is a necessary requirement for them to have the information. When considering if it is necessary to give someone access to the data, it must only be relevant in relation to implementing the agreement. No other reason can be considered. If you do need to share the information, then you must ensure that the recipient of the data upholds the confidentiality and obligations relating to the data noted in the agreement. You may have non-disclosure agreements or confidentiality clauses in your employees' contracts or with other third parties or entities that you need to share the information with. If you do, you should review these clauses and contracts to ensure they are adequate to meet compliance with this agreement. If you do not have these in place yet, you must do so prior to sharing the information with them. For classified information, it must be handled in accordance with all applicable legislation, and this will include compliance with GDPR and the Irish Data Protection Acts. When handling classified information, you must ensure that it is handled securely and that it is protected against unauthorized access, disclosure, or modification. For example, you may have access restrictions on your internal servers to prevent unauthorized access to electronic files, or you may have locked offices and filing cabinets to protect physical files. When sending classified information as attachments via email, you may have implemented a policy of applying a secure and hard-to-guess password to provide added protection if it was to be sent to the wrong email address in error. If you intend to subcontract any tasks that involve the sharing of confidential information, you must request the approval to share the information in writing to Leargas and receive a formal receipt of approval from Leargas before the information can be shared. You may not share any classified information without seeking formal approval in writing from Leargas. As with any non-compliance of a contract, there are consequences. And in this instance, failure to comply with the content of the agreements may result in the reduction of the grant. As covered in the GDPR training overview, the data controller may be Leargas, the European Commission, or another third party. It is your responsibility to ensure that you know which entity is the data controller and that you confirm how the data should be processed by you on behalf of each of the data controllers. The European Commission has provided guidance on data processing on its website as noted on the slide, and this website is noted within the agreement for your reference. As a beneficiary, you must comply with GDPR and Irish data protection legislation. This includes the 6 key GDPR principles, in that the data must be processed lawfully, fairly, and in a transparent manner in relation to the data subject. The data must be collected for a specified, explicit, and legitimate purpose only, and cannot be further processed in a manner that is incompatible with the purpose for which it was originally collected. The data must be adequate, relevant, and limited to what is strictly necessary in relation to the purpose for which the data was collected. This is often referred to as data minimization. The data must be accurate, taking every reasonable steps to ensure that the data is kept up to date. The data should only be kept for as long as is necessary for the purpose for which it was collected and processed. And finally, the data must be processed in a manner that ensures appropriate security of the data at all times, including protection against unauthorized or unlawful processing and accidental loss, destruction, or damage. Similar to the clauses noted in Article 13 in relation to sensitive and classified information, you may share personal data, which is covered by GDPR and data protection legislation, with your employees. However, you must ensure that you have the necessary non-disclosure and confidentiality contracts in place with these individuals before access is provided. You must also inform the data subjects about the processing that is performed on their data and make the European Commission's privacy statement available to them. If you have a website, you can include a link to the European Commission's privacy statement from your own privacy statement. The non-compliance with this article is the same as that stipulated in Article 13 previously. Failure to comply with the content of the agreements may result in the reduction of the grant. Section 3 deals with checks, reviews, audits and investigations. Within Section 3, Article 25 specifically relates to audits. Leargas may perform its own audits or may delegate audits to be completed by an external specialised audit firm. Where Leargas use an external firm, you will be informed. You do have the right to object to a specific third party completing the audit on the grounds of commercial confidentiality or conflict of interest. If this is the case, you will need to inform Leargas, who will arrange a suitable alternate. As a beneficiary, you must cooperate diligently and provide, within the deadline requested, any information including complete accounts, individual salary statements or other personal data to verify compliance with the agreement. Sensitive information and documents will be treated in accordance with Article 13. For on-the-spot visits, you must allow access to sites and premises, including for the external audit firm, and must ensure that information requested is readily available. Apart from Leargas, there are a number of entities who are entitled to audit beneficiaries under current EU legislation. The primary third party is, of course, the European Commission itself. When such audits occur, you as the beneficiary must make available all of the necessary documents and records applicable. In addition to Leargas and the European Commission, Other third parties who are entitled to audit beneficiaries include the European Anti-Fraud Office, OLAF, the European Public Prosecutor's Office, the EPPO, and the European Court of Auditors, the ECA. A complete list of these third parties and the corresponding European legislation is included in the agreements. As noted earlier in the agreement sections, failure to comply with the content of the agreements may result in the reduction of the grant. In addition, costs or contributions may not be eligible and may be rejected. As a beneficiary, you are also required to report on the measures you have in place in relation to compliance with GDPR, your data processing operations, and those of any third parties that you have subcontracted data processing to. Your reporting will be required to be included in the final report. There are specific topics that the agreement requires you to report on, and these are security of processing, confidentiality of the processing, assistance to the data controller, data retention, contribution to audits, including inspections, and establishment of personal data records of all categories of processing activities carried out on behalf of the controller. While you must report on these matters in the final report, it is important that if you have a data breach, you must report it immediately to Leargas and the European Commission. This is a GDPR and Data Protection Act legal requirement and is a different type of reporting to that stipulated in Article 15. As required under GDPR and Irish data protection legislation, you must inform all participants on what and how you process their personal data. You must do this before you upload any of their personal data to an Erasmus Plus portal or system. If you are using or intend to use a subcontractor, you must ensure that they also comply with the security and confidentiality requirements noted in the agreement. You, as the beneficiary, are responsible for ensuring that any audits required to be completed by Leargas, the European Commission, or other third parties previously noted and defined in the agreement itself can be undertaken on any subcontractor that you use. Once the programme has completed, it is important that you are aware that certain elements of the agreement continue to apply. This includes, for example, the confidentiality and security of any data that you hold. The agreement will also continue to apply to your employees and any subcontractors that you use. So now let us do a quick recap on some control examples that can help you in meeting the requirements of the agreement in relation to information security and GDPR compliance. Under GDPR legislation, you as a beneficiary data processor must ensure that you have adequate security controls in place to protect the personal information that you are entrusted with. Samples of some of these controls include policies and procedures, formally documenting your organization's requirements on manual and technical controls to protect the data and the devices on which it is stored or processed. Awareness training for your employees in relation to the implementation of the security controls and processes. This would include not only training on your information security policy, but should also include phishing and social engineering training and how to recognize such attacks. And training should also include your GDPR and Data Protection Act policies and how your employees should comply with these. Technical controls that will assist you in the implementation of appropriate controls to protect the data. This could include, for example, antivirus software, disk encryption on laptops and desktops, the use of multi-factor authentication, for example, a code received on your phone in conjunction with your user ID and password to log in to your email or applications, or ensuring your patches are applied to your devices on a timely basis. Data backups, to have the ability to recover data and make it available in a timely manner in the event of a systems outage. Ongoing assurance of your security controls to determine if they are adequate and effective in keeping the data secure. It should be noted that these are just samples of security controls that you as a beneficiary should have in place. For further information on GDPR, Data Protection Acts and Regulation 2018-1725, you can access and search these websites. The Irish Data Protection Commissioner's website, www.dataprotection.ie, the UK's Information Commissioner's Office website, www.ico.org.uk, and the European Commission's website, commission.europa.eu.